Hi everyone, welcome to Litigation Help. My name is Heather. So joining me today, I have Dan Rossman. So Dan, your law firm is Rossman Litigation, I believe. Is that
That's
right?
correct. I'm a civil litigation lawyer based out of the Greater Toronto Area, and I help clients, individuals and businesses with civil litigation needs.
And how long have you been practicing?
5 years.
Wow, yes, congratulations.
Thank you very much.
So today the first topic we're going to talk about is rules. I know that I remember when I was a self-rep, that was a major obsession of mine. I was very worried about what rules I have to follow. Can you just kind of like bring us up to speed as to what the rules we have
Right.
to
So, you know, in a lawsuit, people are often very concerned about the law. Right?
Yeah.
So if they're in a dispute, let's say a contract dispute,
Right.
someone breached the contract, they're very concerned about the breach of that contract, the legalness
Yes.
of that. But they also have to be concerned about the procedure, the rules of going to court, how long they're going to be able to talk to a judge, what are the rules about submitting your material, what form those materials are going to be in, how do you book your day in court, things of that nature. And all of those procedural issues are governed by the rules of civil procedure. So the rules of civil procedure are very important because it is essentially the guide to how you're going to bring your case and the guidelines of what you're going to do in your case. Now, there's also other rules, which you were asking about, which also govern the way your case is going to be managed and handled. And they're going to be in, for the specific court that you're in or in the province in general. And those are called practice direction.
Okay.
So how long you have to tell a court staff to confirm to the court staff that your motion is going to go ahead will be in the practice direction.
Right.
How long your factum is required to be, or if you're required a factum at all for a specific motion you may be bringing, will be in a practice direction. It might also be in the rules of civil procedure as well, but you're going to have to check both to know.
So where do we find these rules?
So everything's available online now, which is great.
Okay.
CanLII, which is a free resource which provides you with case law and statutes. It also has the rules of civil procedure there. The practice directions, the Ministry of Attorney General makes those available online. CanLII might as well, but I know for sure that the ministry does.
Now, when you mentioned the word case law, for those of us who don't know, because I definitely didn't know that there's such a thing when I was before I went to law school. So can you just give a brief explanation?
So, as I said originally,
Okay.
there's the two separate areas you got to be comfortable with. There's
Right.
the law, and then
Right.
there's the procedure. So, case law is the law.
Oh,
Right,
okay.
so the law comes from statute, it comes from common law, and case law are the decisions of previous cases where a judge will interpret that law, will look at specific facts in that case and put them together, and it's very helpful in persuading the judge in your case and very helpful in you understanding the law for yourself when you're preparing your case.
I see. And so I guess a case law, just like the rules of civil procedure, you can find that on CanLII as well.
You can find a lot of case law on CanLII. I mean, CanLII is pretty good for the last few years, but I think they only really started reporting most cases in the last few years. So anything older, you might have to go down to a law
So
library.
not everything is
Not everything,
Not
no.
everything. I see. And I also, one last thing that I want to kind of like bring up in this video is I know that in law school we learned something called the rules of evidence, which
Right.
well, I remember there was a whole course on it.
Right.
Is that important to like
Yes.
for people representing themselves? Should they care?
Yeah,
I mean,
so evidence is very complicated, and there's
Yeah.
no way that I'll be able to talk
Of
in
course.
detail about it in this video. But evidence is a mixture of statute. There's the Canadian Evidence Act, there's the Ontario Evidence Act, which talks about what type of evidence you can use in your case and how you can use it. And then there's also principles that judges have developed over the last, let's say, 800 years about evidence and how you can use it. So an example is if you want to tell a judge that you saw a specific thing happening, how do you tell the judge that? You can't just go up and say it to the judge. You might have to be sworn in first. that you're swearing to tell the truth, that'll be part of the evidence rules. You would have to say that you saw it yourself rather than you heard that someone else saw it. That would be a hearsay issue. So evidence is very, very complicated. I don't want to get too detailed into it today because but it is very important that when you want to tell a judge something in any context, whether it's a motion or in your trial or anything like that, that you are, take a look at the evidence rules and make sure you do it properly.
So basically you can't expect to just go into court and tell your story or show a PowerPoint or something like that, right?
No, you can't. You have to know how to do that properly. You can go to court and you can tell your story and you can use a PowerPoint, but you have to follow the rules of evidence in order to do it that way.
Okay. So it's possible, but
absolutely.
But it's not like completely common sense.
Exactly.
Okay. Well, thanks very much, Dan, for that helpful insight.
You're very welcome.